So the floor is now open for your comments and questions. We have around 20 minutes for that. I'll take 3 questions and then put them before the panel. Et je répète, si vous désirez poser votre question en français, cela est parfaitement possible. Je la traduirai ainsi que la réponse si vous le désirez. Okay, I see 3 hands already. 1, 2, 3. Yeah. Okay, Adrian, you can go. Yeah.
So I wondered if there was a tension between the papers from the 2 Davids. So David Bilchitz, your paper proceeds from premises. If we properly understand what rights are and their place in the constitutional scheme, we'll prioritise their meaning over the institutional question. Whereas I guess David Landau's paper, as I understood it, was really talking about the changing role of courts over time that is justified primarily by questions of outcomes. And so it's introducing, I think, considerations that are not identical to, but seem very close to the kinds of considerations that David Bilchitz wants to exclude. So I think you two disagree with each other, and I'd love to hear whether you do or whether I'm wrong.
Okay, think about that for a while Vicky asked her question.
Oh, well, these were wonderful presentations. I wanted to ask, I have a question for the 2 Davids, I think. So for David Landau's, I want to ask David whether you really want to argue that we give up asking what courts do as courts. And here's the thought. Is it possible that the court's ability to be effective may depend in part on people experiencing them as acting as courts in the sense of fairness and hearing parties and so forth? And my question for David B. Is whether the elegant argument you're making is one that might reflect the structure of the articulation of rights with a separate limitations clause, and an argument to keep separate the question of what governments realistically can do from the prior question of giving a full understanding of the rights, and just whether that came out of the text in that way.
Thank you. I have a question for Professor Landau and Professor Deva. I'm interested in the definition or the meaning of policy, because we see the constitutional courts, often deferential courts would just, hide behind policy and treat policy as if it's some magic reason not to intervene. So in South Africa, there's very little to work with in terms of, a definition. People have used the word plan. It's a government's plan. I'm interested in the US, Colombia, and India, whether there's been some, deeper digging into this issue.
Okay, who wants to go first? And yeah, David Bilchitz. Yeah.
So, do David and I disagree? I'm not sure. I mean, I need to think through it more deeply. I suppose, in my view, the judicial role. Well, firstly, I mean, there's a question about the relationship between separation of powers and rights, and my argument is that separation of powers ultimately needs some conception of rights in order, because part of the whole point of the institution is itself to realize and recognize rights-based outcomes, I suppose. So you could reformulate what I'm saying in terms of outcomes. So the separation of powers needs to be configured in such a way that it achieves the fundamental rights of individuals, and I don't know if that's sufficient to put me. I'm not sure that I'm not going to like an instrumental argument for rights. So if David is arguing that rights are themselves to be protected for various utilitarian reasons in relation to the political community and advancing the political community, there I'm going to resist, because I'm going to say that rights are founded in fundamental worth of individuals, and that those entitlements exist. There may well be reasons to limit them, but they are not subject to justification in relation to some kind of broader collective goal. So there may be their tension between us, but to the extent that separation of powers will themselves be seeking to attain outcomes that are rights respecting. I mean, I think I could go along. I like many of the Colombian cases. I think they show the way in which courts, it would be interesting to hear to the extent to which courts have separated out understanding rights from the institutional considerations in relation to rights. My sense is the court has done better than most courts around the world, because it sought to give some kind of content. So on something like the the case in relation to internally displaced persons, the court actually specifically outlines what a minimum conditions must be for the treatment of individuals, which provides some understanding of rights without conflating them completely with separation of powers considerations, which I think our court does in South Africa. So I don't know if that completely answers it, but I think we sort of need to engage a bit more on that. And then, Vicky, I think that's a really interesting question about whether it's because of working very much within the realm of two-stage inquiry of is this a violation of rights or infringement of rights, and is there a justifiable limitation through which my argument comes. I'm not sure, and I mean, again, I would need to discuss more with you in relation to the US context. Obviously, I know there's no such strict separation in that regard, and there's no limitations clause. At the same time, at the first level, does it make sense to basically bring in, you might not have that kind of clear, articulated structure of constitutional inquiry, but isn't it still required analytically to have some prior understanding of what the interests are that are protected by the rights before you engage with the institutional considerations about their realization? And my sense is that one could replicate it even in the one-stage model of a kind of US constitutional system, but because analytically that's required. Now, my sense about, and maybe the undesirability of the one-stage system, is that it often just brings everything together and it gets confused. But isn't a proper articulation of a rights-based doctrine, even in that setting, requiring to at least engage with the fundamental interests underlying it before you start bringing in all those other considerations involved? So, I mean, that would be my argument.
Okay, David, all three questions apply to you.
Sure. Yeah, I don't know if we disagree there. It's a good question. I'll need to give it more thought. I mean, I think to the extent that you would conceive, or that I am conceiving, separation of powers as an instrument in the service of other goals, which I think is very consistent, certainly with the fabric of Colombian constitutionalism. I don't think there's a disagreement right on that point. I mean, I think there we'd be in agreement that it's an instrument in service of more fundamental rights principles. Whether there's some sense in which we disagree on the meaning or importance of rights themselves, maybe, yeah, I need to think that through, right? I think particularly the second theory, the sort of political process or political improvement theory, it may well be that there's some tension. I think at the end of the day, whether it's just for, because we certainly are different methodologically in terms of the way we approach legal problems, but I think at the end of the day, with respect to this project, we get to very similar places, whether or not there's a tension at the root. But I think it's a good question, something I want to give more thought to. Vicky's question, also I think really interesting. I think that may be right, that even if one is a thorough pragmatist, as I guess I would define myself, there's some sense in which if the court acts sufficiently uncourt-like, it's not going to be successful. I will say I think it's interesting to think about the flexibility of that sense, though, of what being court-like is. Right? I mean, I think the Colombian court has certainly successfully stretched that conception. It's done it partly by playing off of a sense of the dysfunction of other branches, right? So it's justified itself partly by saying, well, we have a problematic legislature, for example. We have a problematic executive branch on certain questions. And I'm not entirely certain that's a good thing, right? I mean, I think that move itself, which has allowed the court to be more aggressive, may have some negative feedback effects. I certainly think there are some limits, right? I wouldn't want to give up the sense of, well, it's a court as opposed to something else completely. But I think it's a much more flexible conception, right, than one might sort of think as a starting point. The last question with respect to what's a plan or what's a program, I don't know. I might leave it to either Danielle or Manuel Jose Cepeda to lead the specifics of that. But I think that my sense with the structural cases is certainly it's not enough to have something out there that you say is your public policy on the question, right? So the displaced persons case, for example, there was a law, and certainly the same is true of health. There were laws in both of these areas that set out guidelines for how the state ought to treat actors, and the court wasn't satisfied with that, right? Because essentially it said there might be laws, but the point is you're not carrying out any of these fundamental sort of policies that underlie the law. You've got to do a lot more, and the court's certainly been more willing to get into the specifics, right? So there's some sense, I think, that you need to not only sort of create a program, but it's got to be a real program that's being enacted, and it's got to fulfill a number of different goals that come out of domestic constitutional law and international human rights law to some degree. So it's been more aggressive, I guess, in defining kind of what counts. I don't know if that's a sort of sufficient answer, but that's my sense.
Surya.
Okay, in the Indian context, I mean, the policy is like a broad umbrella which will cover all issues about program of actions or some policy matters or some proposals. You can give it different label, I mean, but these are basically different tools by which the government is saying that we will try to accomplish the constitutional goals. And there is no one way to achieve those goals. So these are broad objectives, and there have been issues, for instance, about should there be foreign direct investment in the retail sector. It's a policy issue. Should we open up the insurance sector? Should we get investment in the airline industry? So these are the policy questions. But there also have been questions about should we establish a separate court, for instance, to deal with crimes against women? So that is again a policy question. So there is a broad range of things that are taking place, and policy is kind of the overarching umbrella within which the court are going to put. But again, in many cases, they sort of do reverse reasoning. If the court is of the opinion that we will not interfere, they will reverse reason it and say it's a policy matter.
Exactly.
So, and I mean, and that is very typical of judges. So we can't say much on that. So there's a lot of room for flexibility and discretion when they want to interfere, when they don't want to interfere, and there's a lot of incoherent jurisprudence, at least from India, on that particular point.
The University of Johannesburg. Rethink, reinvent.